Ladies and gentlemen, we're going to get started pretty soon. Just a reminder to turn off any electronic devices that might make some noise. All rise. The Court of Appeals Division 1 is now in session.
Thank you all. Please be seated. Good morning. This is a time set for oral argument in re Noise Hanscom, our case number CA CV12-0575. Each side is allocated 20 minutes for oral argument. Appellant, you may wish to reserve a portion of that for rebuttal. If you do wish to do so, please keep track of your time. We will not be keeping track of it for you. And there is a clock at the podium. Out of respect for counsel, I would ask those in attendance to make sure that their phones are turned off so argument is not interrupted. Counsel, we have reviewed the briefs. We've conferenced the matter this morning. We encourage you to keep that in mind as you present oral argument. Our proceedings are being recorded as well, so please, as you begin your argument, state your name and the party that you represent. With that, let me first hear from counsel for appellant, Mr. Bain.
Your Honor, my name is Donald Smith. I'm here.
I'm sorry. If I looked a little bit more carefully, I would have caught that. Counsel, I apologize.
It's all right, Your Honor. I represent the appellant in this matter, Evergreen, and I'm going to try to reserve, depending on your question, 3 minutes of time for rebuttal at the end, and I will watch it. We've been here on this case once before, unfortunately. We're back. The issue now becomes whether the trial judge, when he went back below, appropriately found that there was substantial evidence to support the award of damages of $1.8 million to Chandler. We submit to the court that the evidence on the record in this case is there really was no evidence about the end of it, about the damage to Chandler, who was 2, almost 3 at the time of his father's death, as to the damage upon him. And without that substantial damage and the finding of the trial court at the time of the original review, which occurred a few weeks after the trial, in which he stated that the action of the jury was to punish, he felt that, based on the evidence, he felt that the jury had decided to punish the Evergreen for their actions, that they did not follow the instruction, and that time was the best time to show what the evidence of substantial damage was. Going back to the time of that trial, the evidence was that Mr. Hanscom was in terminal condition 2 months to a year to survive. For our purposes here, assume the 1 year survival. He was in Evergreen Extended Care Facility for that purpose, to be treated for that purpose. He was not going to return home again. The simple fact of the evidence. So then what evidence was there concerning Chandler, not concerning Mrs. Hanscom, not concerning Mr. Hanscom, but what was the evidence on Chandler?
You said as you opened that there was no evidence concerning any damages to the son. Is that real? Can you really say that?
Yes, ma'am. Yes, Your Honor. And let me explain why I say that. The evidence that was presented was Chandler was 2 to 3 years old. There was evidence that he lost his father because of the death. Now,
He lost a year. Arguably, he lost a year.
A year.
So you're looking at what's the effect of that loss.
That's where there's no evidence. When I say there's no evidence of that effect. You have an unusual circumstance when you're dealing clearly with the loss of to a child of a parent when the child's young. When you're dealing with Miss Hanscom could come up on the stand and did sit on the stand and look at the jury and say, here's how I feel. Here's what it did. they never saw, the jury never saw Chandler. He never was in the courtroom. There was no evidence from anyone else about Chandler's being affected this way. So when you're dealing with this young a child, really you can't put them on the stand. So you need to have them evaluated. You need testimony to say, this child knows he lost his parents. This child is feeling this effect of that loss.
Is there a case for the, you're saying that the plaintiff needed to offer expert testimony to that effect?
And only when you're dealing with a child that's young.
I understand. Is that your proposition?
Yes, Your Honor.
Is there a case to support that?
No, because it's always been done. As a matter of fact, I just saw it done. I just saw it done in a trial about 11 months ago in a matter that was before this court in a case called Connolly. Parr was when it was here before this court. That was not the issue, but that was one of the cases. The issue there was they called a play therapist in. The child at that time was 9 and 10, there's two children. I believe that they were 9 and 10 at the time. They were a play therapist came in, and if you've ever seen play therapists, because you can't get a child to be as verbal, they have them draw. And that person showed the drawings and said, look, this child is missing. See here where they show this missing limb. That's a show of the parents, the missing parent. That is what you need to do. That was not done.
Counsel, isn't the sort of logical extension, let me ask you a different hypothetical. The child, instead of being 3, is a newborn.
Correct.
Your position is, and presumably may not become vocal during the first 12 months of his or her life, your proposition is that child could never successfully recover anything in a case like this.
No, Your Honor.
Okay, help me understand that then, because I thought you mentioned that there is no evidence that Chandler knows of his loss, and in that circumstance, the child, because child isn't verbal, couldn't objectively manifest loss.
But you could put testimony out that the damage to a child for the loss, say it was a father, which is what we're doing.
Right.
For the loss of a father is these effects, and that
Abstract testimony by a...
well, and say to a reasonable degree of medical probability, a psychological probability probably, this is what this patient's going to, and a jury could consider that evidence. That's what the jury did not have. And
so your position is it has to be expert testimony, could not be within the experiences of the jury as, before they came to the courtroom. It
No.
has to be an expert.
yes, and Your Honor, when we're dealing with a child like this, not when we're dealing with an adult who can say here.
I understand, and
Yeah.
let me use the newborn hypo that I had
Yes.
suggested. You're saying you have to have expert testimony for that.
Yes, Your Honor.
And was that an issue that was litigated before trial?
That was no, Your Honor, because the issue, they didn't try to do what they did later, and it ties into one of the other elements we raised. The risk here is what you're doing with the jury is when you go what we call the violation of the golden rule. When you tell the jury, what would you want for this? What would you want? Now you tell the jury to go out and say, put yourself, if you were Chandler, what would you want? You didn't let them start applying their own standard of practice. You start leading them down a path they cannot do. We raised issues. Could they have reasonably said to the jury, Chandler has lost, and the evidence they put on, okay, Chandler has lost his father, and stopped, and asked for an award of that, and try to do what Your Honor suggests. Can you rely on the jury to do this? And then rely only on like mom's testimony. He asked about his dad. Mm-hmm. Yes, but you can't then go out and say to the jury, you got to give Chandler money because this loss is going to last forever, for his entire life. That's the evidence they're missing.
Okay, I wasn't listening.
Oh, I'm sorry, Judge.
Appropriately. No, yes, don't apologize. It's my fault. Did the defense argue at trial that the son was entitled to no damages as a matter of law for the lack of expert testimony?
No, Your Honor.
Okay.
Because I think he's entitled to the damages. The way they get to the $1.8 million, and you saw it in the arguments before this court, is his loss is not for that time. His loss is for today and tomorrow and for 40 years of his life and for 50 years of his life and then for 70 years of his life. If that wasn't argued to the jury. That's what the jury ran off and did on their own. That's totally on their own. What they did here is, remember, because if you read the closing argument, what would one more Halloween be worth? What would one more Thanksgiving be worth? That's kind of damages in the past, but they didn't have damages for the future, about he's going to be suffering for this when he's 50 and 60 and 70. That's the kind of thing, and what that damage is what they are lacking. And that's how the jury, that's how the appellee and justifies getting to $1.8 million, because the damage continues for his entire life. And there was no evidence on that. So, and what the defense argued at trial was that the compensation is this is his loss. But remember, he only lost a year at the most. He didn't lose 50 years or 60 years. He lost a year with his dad.
And the argument, I think we're going to hear later, is that the memories in this particular circumstance, where the life expectancy of the father was but a year, what the son was deprived of are the memories that would have been formed in that year.
And you're absolutely right, Judge. If you're going to argue that, then you've won. First step for damage, not for causation.
Yeah.
The death causes harm. But what you've got to do is put on a person that shows a 2-year-old will have a memory of his life when he's 50. And that's what we're missing here. That's one of the things we're missing here. The recent medical articles indicate that basically you have memories from about 4 on. They need somebody to come in and say he was going to have a memory of 2. He would have remembered that Thanksgiving. He would have remembered that, and he's now deprived of it. That's their burden, not the defense's. And they never raised it during discovery, so we never countered it. We never got our own expert to come in on that issue and said, here it is. Their damage was, here's the wife and the son, and there it is. Now they're trying to stretch it out, and that's inappropriate.
So is it your argument then that you must have an expert for future damages? I mean, or are you saying past damages as well, in other words, when he's 20 and 30 and 40 and 50 years old, you have to have an expert to come in and talk about that? Can the can the parent not come in and say he misses his dad, he asks about his dad, he wanders around the house looking for him, those kinds of things? You said that those were past damages. So is your argument that they have to put on expert testimony for future damages?
Well, one thing is that's what they're arguing for now to justify the $1.8 million, is that the damage doesn't end with the year. The damage goes 20, 30, 40 years, 50 years into the future. If you're going to claim it, you have to have evidence of it, not that he'll adjust to it. And that's an issue the jury should have been advised of, and it wasn't. Now, let me go back to your question about today. Couldn't the mother testify? He comes in, this didn't happen, okay? I don't want you to think I'm saying this happened, but he said that Chandler comes in at night and he cries, and he tells me he misses his dad. Could she tell him to tell the jury? That's a fact. That's what she observed. That's testimony that's allowed. Can she then say, he's going to come into my bedroom when he's 42 and cry? I'm being facetious. But the point is, that's what they don't have.
That's what you say they needed expert
That's
testimony.
what they need.
Because they needed to show that the child would have developed a memory in that year.
Yes, Your Honor.
That he would miss.
That's the substantial evidence we're missing. So, Your Honor, I'm trying to really make sure I'm clear on that is, can the mother testify, or an uncle or an aunt or the neighbor, what they see with the child or what the child tells them? Absolutely. That's a fact witness. That's what they see. But when you want to take that step and go one step further and keep going, then you've got to have expert testimony. Because I would submit to Your Honor, if the only damage is Chandler was perfectly fine at 4, and they say he's never going to have any more problems, so the only damages is 1 year, it'd be kind of hard to justify $1.8 million, except for the anger the jury felt, that the judge said the jury must have felt at the defendants. That would be, there's a case out there, I think, Youth Candy, if I remember correct, it says when there's no way to justify the verdict, it's so excessive, then you can assume bias and prejudice that it appears itself. If you only had that damage, then that would be 1.8. It has to be based on bias and prejudice. In this case, the fact that they didn't like Evergreen, they didn't like the extended care facilities, and there was all the evidence and all the discussion during trial of the bad acts.
On that point,
Yes.
since time is short, would you explain to us your punitive damage argument? How, since the jury did not award punitives, how can it be that the court erred, or how does the fact that the court instructed on punitives bear on the denial of the motion for new trial?
Okay, see if I can do this quicker. Because of the issue of punitive damages was based upon out-of-state law, Florida, which has a much different standard for punitive than Arizona does, and are far different than the evidence in this case. It allowed them to portray Evergreen in, and let me give the court some examples of how they did it, so this will maybe fit in easier. For example, there's a missing spot where there's supposed to be a pain med given and it's blank. There's a picture, and you put your initials in when you do it, and it's blank. They argued, if you read and they asked question, had their expert testify, that someone must have taken that med and not given it to him and taken it and stole it. So they were stealing of meds. There's no evidence of that. They just...
Not the instruction?
It's the fact he kept allowing the evidence in, and it kept piling up, and the jury got angry and wanted to punish it. And by the way, that was a trial court's conclusion a few weeks later. He said they got angry at you, and they must have felt they couldn't get to the level, because the instruction on punitives was correct, the level of it. He said they must have figured they couldn't get to it. This was the trial judge's conclusion. It's cited in our brief. And he said they must have decided they couldn't get to it, but they wanted to punish you, and that's how they got to 1.8 million.
So it was the admission of the evidence, of evidence that, not the instruction.
Not the instruction, the admission of the evidence repeatedly throughout the trial. The court kept allowing it in and kept allowing it to be emphasized to the jury.
But if you concede it was proper to instruct on punitives.
Okay, let me make sure I'm making I'm not saying he shouldn't have let the evidence in, and he shouldn't have instructed. He should have not let that go to the jury. My point is the jury instruction. If you're going to let it go, the jury instruction's right.
Counsel, let me see if I can replay this. Your argument is that the expert evidence shouldn't have been allowed, and if that hadn't been allowed, the jury shouldn't have been instructed on punities, not that the instruction given was improper.
Correct.
Okay.
Yes.
I just wanted to make sure.
Yeah. Because if you're going to let it go, the instruction he gave was correct.
Okay.
Yes. I'm down to about 4 minutes. Is there any more questions for me now?
None at this time. Thank you,
All right.
Counsel.
Thank you, Your Honor.
Mr. Bain.
Good morning, Your Honors, and may it please the Court, my name is Scott Boehm, and I represent the Hanscom family as appellate counsel. Before I get into my pitch, I do want to clarify a couple of factual misstatements that were made during Mr. Smith's presentation. These are confirmed by the record. Noyes was not in the nursing home for his cancer. He was there because he fell and hit his head and had to go to the hospital for his head injury, and then came back to the nursing home to transition back at home. So the idea that this was somehow related to his cancer is not true. His cancer at that time, while terminal, was under control and certainly not in remission, but the evidence from our side was that Noyes was going to be going home and was still able to move around and essentially live his life, and would have been able to do so for another year. Their point, which we heard several times, was that Chandler was only 2 at the time. In fact, he was nearly 3 when his dad died, and as the Court of Appeals pointed out in Judge Weisberg's opinion, he would have been nearly 4 at the time that Noyes would have been expected to have died from the cancer. So that represents 25% of his life at a time, and there was evidence of this from Colleen, his mom, that he started becoming more active and more vocal and all the things that 4-year-olds do, or nearly 4-year-olds, that 2-year-olds don't do. It's important, I think, for me to reiterate, and I covered this very heavily in my brief, primarily because it was not addressed in the opening brief. The evidence here was undisputed. Pretty much everything I heard from Mr. Smith about this expert testimony and the need for it, I was hearing for the first time. That was not mentioned in the brief. It was not mentioned at trial. There was no motion to preclude any damages claims for the lack of expert testimony. There's no case law on that because it was never brought up in the briefs. This is something that I heard for the first time here today. At trial, the plaintiff's evidence regarding both Colleen's and Chandler's damages, they were presented at the same time, primarily, of course, through Colleen. But it was, at that time, even though Colleen was awarded 0, we were still seeking damages for her, and in addition for Noyes, because he was awarded $200,000 for his APSA claim, because, well, he would have been alive during that time, interacting with his family as well. Our damages were not contested. They didn't challenge our damages, our damages evidence. They didn't file any motions about the need for expert testimony. They didn't present any damages evidence of their own, and they didn't even address damages in their closing argument. They just kept pointing out that he was going to die within a year. And as Judge Weisberg pointed out in his in paragraph 15 of the 2011 opinion, that's you have to come up with something. And one of the things that trial counsel now Judge Ostrowski argued here was that, as Mr. Smith anticipated, these damages this pain and loss is not going away. And I would even argue that Chandler's damages and his sense of loss is going to increase as he gets older, because the extra year that he would have had with his dad is never coming back. And he's going to be aware of that forever, particularly because the family knew that Noyes would have been dying. Colleen testified about the things they did, and that Chandler was Noyes' little buddy, and the things that they did together, and that pennies from heaven anecdote gets me every time. And the evidence was also undisputed that after the death, Chandler kept talking about his dad and kept, as Judge Orozco pointed out, mentioning this is the penny from heaven that my dad can't give me anymore. And I think it's important also that because they knew that he had another year, and because there was such a close relationship, and Colleen testified extensively about the very tight relationship between Noyes and Chandler, because they had tried so hard to have a kid, and Noyes, Colleen had some older boys, but it was he finally had his son, and they did everything together. And given the fact, and the evidence was that, because he knew he was going to die, that last year would have been stellar. I mean, they would have had pictures, they would have been able to celebrate, he would have been able to help him with his big wheel, all the things that he was deprived of. And given to, not like back in the old days when we were growing up, kids' life now is pretty much all on film. And as Chandler got older, 48, no one's suggesting he was going to be crying to his mother at 48, but he would have had pictures of him and his dad, and pictures of him maybe sitting on his dad's hospital bed, reading books, and in his Halloween costume, and opening Christmas presents. This is all, and I'm not just making this stuff up, this is what Brad talked about with Colleen during the trial, and this is what Judge Weisberg pointed out in his opinion. I'll read it to you. As Chandler's counsel argued to the jury, another year would have given Chandler more time to form memories and to celebrate holidays and special occasions. It is not inconceivable that the jury considered such factors. And I think, excuse me for 1 second, I think one thing we need to keep up front is the standard of review that we have here. I didn't hear Mr. Smith say anything about Judge Trujillo on remand acknowledging that he had substituted his own personal feelings, which was kind of what their opening brief argued, and the reply brief too, actually, for that matter, that they were, basically arguing with Judge Trujillo that, well, you really didn't substitute your own opinion. Well, that's something that the judge knew, and he candidly acknowledged it. And then, based upon the law that Judge Weisberg gave him in Hanscom, he went through and reanalyzed everything and came to the conclusion that this evidence, the 1.8 for Chandler, when the damages are viewed through Chandler's eyes, which is the key, was supported by the evidence. So that's what we're up here on. And what the standard of review on that, under the Kramer versus Triano case, the Winston and Strawn case, and the Hutcherson case that Judge Weisberg talked about, is the greatest discretion under the law.
Do you think that the comments by the trial court judge in issuing his first ruling bear at all on the analysis today?
No, I don't think so.
Why is that?
Because, that was when we were up here last time in 2011 or whenever the heck it was, I was the appellant on this issue, arguing that the trial court substituted his personal feelings for the correct assessment of the evidence. Mr. Smith argued the contrary, and the Court of Appeals decided, we really can't tell, because although the judge made some statements that you're referring to in his ruling that seemed to indicate he was following the law, but he also made some other statements that made it very uncertain. And I think the Court of Appeals holding of uncertainty, given the uncertainty in the record, I'm looking at paragraph 16 now, we're sending it back essentially for Judge Trujillo to take another look at this and tell us, did you follow these things or did you substitute? And he, to his credit, said, I didn't follow the law, and I, now I'll do it. And he went back and he said, in the oral argument, which there was no new briefing, no new issues, all the stuff about the punitive damages and the collateral source rule, none of that stuff was dragged up again. They just went back with the opinion in hand and the former pleadings and had another argument. And he pointed out that he had read the Court of Appeals opinion, I think he said 6 times, and he was more well-versed on the law. And then he, for a bad analogy, fell on this sword. I was a little surprised, because it would have been very easy for him to say, I did this right the first time, and it should be $500,000. 1.8 is too much based on the evidence. And we'd be up here with the same standard of review, and I'd be going home with my tail between my legs. But the reality is he looked at the evidence. He was the judge that was there. Yes, it was 3 years later that he looked back at everything, but he had the trannies, he had the briefs that we cited everything, and his conclusion is very warranted, let me say, because he referenced the evidence in the record and the arguments and the undisputed evidence. I'm kind of at a loss to respond to you need an expert witness to tell the jury that people's sense of loss is not going to go away over time. I've never heard of that before.
Mr. Baines, are you saying that argument regarding expert testimony was not even brought up in the motion for new trial?
No, it was not. And let me be very clear about it. The idea of a remitter was never brought up in the motion for new trial. That was brought up as just kind of I have the motion for new trial right here. This last slide. The motion for new trial was based on all of what I call them the crumb issues here. Was there sufficient evidence for punies? Was the collateral source instruction, should that have been given? What about the disregarding insurance? Those were the issues that they sought a motion for new trial on. In reply, in the trial court, they said, and if you don't agree with any of this stuff, then remit the verdict. It was a little bit more elaborate than that, but not frankly much. And that's when Judge Trujillo said, well, if you want me to remit this was brought up at oral argument, what about Colleen's? Because really, you gave her nothing? And then that's where we all came up the first time, them arguing about the 1.8 down to 5, or that was me arguing about that, and them arguing about the zero up to 200,000.
Counsel, let me
So that's
ask-
how it all came about, Judge.
Let me ask, with respect to the motion for a new trial, the golden rule argument was raised in that motion.
Yeah.
Your brief, I think, says it's waived, although it was subject to a motion in limine pretrial that I rather gather wasn't opposed, and a court then issued an order granting that motion in limine. So I'd like to hear from you more on
Yeah,
that.
and let me grab my brief here, because then I can look at the actual language that Brad said, or Judge Ostrowski, in his closing. And I think, I know what my argument is, but I want to get the language here so that I can tell you why I say this. And this is at 18 rolling over to 19 of my answering brief. Mr. Ostrowski said, and really the amount that will compensate Chandler and Colleen is what value Chandler and Colleen put on that, and we're asking you to assess that. What would you pay to have another day with your spouse, another month, blah, blah, blah. And then he suggests $5 and $10 million.
Well, and one of the blah, blah, blah that caught my attention was, what would you pay as a 3-year-old to have another day with your dad?
I think it depends, frankly, what emphasis you place on the language. If Brad said, what would you pay? And he said it twice. What would you pay for another holiday with your spouse? What would you pay versus what would you pay? Yeah. And when you read the whole thing in context, it's just kind of flowing. And there was no objection to that at the time. And as I pointed out in my brief on most of their latter arguments, there's no citation in the record to any objections on any of this stuff. So I would my response to that is to finally answer your question 5 minutes later. Judge Trujillo was there at the time. He heard what Brad said, how Brad said it, whether he emphasized the you, and it's if he did say that, and I wasn't there either, and the record's cold, but Judge Trujillo was there. What would you give? What would you pay? That's wrong. But if he's just saying what would you pay for, then it's not, and it's not. I don't even think it comes close there. That's my response, Judge.
Thank you.
What about the punitive damage argument? As I understand what Mr. Smith said just earlier, the defense contention is that the court erred by allowing certain evidence in that would have gone, I surmise, only to punitive damages, not to the merits. Was there such evidence admitted, and were there objections to those specific elements of evidence?
No, and I don't want to tell you what Mr. Smith's argument is, but I don't think that's his argument. My understanding of what they're arguing about punies is that the evidence, the prima facie evidence for punitive damages, was insufficient under the conscious disregard of a reasonable risk, blah, 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 standard. And the trial court, therefore, erred as a matter of law based upon the evidence, either by summary judgment, I don't even remember if he filed a summary judgment, or by DV, in letting punies go to the jury. As to the evidence itself, nothing I read in the record, and nothing I heard today even, and I don't even think this is their argument, was that there was just some special punitive damages evidence. So the evidence regarding punitive damages was exactly the same as the evidence for abuse, neglect, and wrongful death. None of which, I might point out, is mentioned in the opening brief or the reply brief. I was chicken to just point that out, so I went through it pretty carefully in my answering brief. But I think the issue there, if you get to it, because this wasn't discussed when we went back, and there's no question that the jury instruction on punies was correct, or the jury instruction on damages. But the issue there that was raised in the motion for a new trial and then brought up here again was whether there was prima facie evidence to go to the jury, i.e. a fact question. And I don't think that's even debatable. And frankly, Judge Trujillo said the same thing. For once in my life, I'm going to stop with 319 left unless you have any questions. Thank you very much.
Thank you, Counsel. Mr. Smith, rebuttal.
Thank you, Your Honor. Interesting statement by counsel during a rebuttal argument. Chandler's damages can increase in the future as he gets older. You just heard that. It's going to go back and said he was going to go back and show how Chandler's damages will have changed and actually increased. There's no evidence anywhere in this matter. And to be honest, one of the strange things about this case, I'm the only trial attorney that still exists that was at this trial.
Well,
on either side.
existed, Lord. As a traveler.
I don't know what that says.
Do you think that, I mean, I can remember a few memories when I was 3 or 4. Is your proposition that the reasonable juror can't conclude that one may have memories?
If you're going to claim a damage for that and for in the future and this with Dad and by the way, this stuff about there would have been videos and there would have been special treatment, I don't remember that at trial as being evidence. The evidence was he had a year to survive, and that might have been special. But to Your Honor's point, you might remember some things, but if you're going to claim that as a damage for to your 21, then you need evidence to establish that there is damage for 21, and that's what they didn't have here.
What of his argument that that this whole idea of expert testimony needed for the damages was not raised until just today?
Well, Judge, I have repeatedly yelled, screamed, argued to various judges, trial judges, Court of Appeals judges, there's substantial evidence lacking to support the verdict of 1.8, and that is lacking because there's no evidence on this future. This is going to go on forever and ever. I cannot imagine how else I can raise that. I've raised it over and over and over before the trial court. And one thing to remember about the trial court.
Let me interrupt you for a second,
Yes.
though. Have you said, look, it's lacking, and I understand what you just said, but have you said in your briefing that it's lacking because there was no expert testimony on the point? I guess I don't recall that, and I want to understand where it was raised.
It was in front of the trial judge at the oral argument. Did I say expert specifically because the evidence was lacking? I don't think that magic word is in the brief, if that's a magic word, but it was raised below. They've heard it before. It was argued at this court before that they had no one to testify to this. And the simple fact is they had no one to testify to this, and part of it is that really wasn't their claim before they got up in closing argument. They had never put it in their they've never put it in their disclosure. They had not really raised it. They said, we're claiming his loss for this year. And that was their claim until they got to trial, and then they changed it. And we raised it to the trial judge at that time. One thing to remember about the trial judge at this time, when he says the jury did this, the jury wanted to punish you, he said, quote, and we cited in our brief, I wanted to punish you. So he came into that mindset that he wanted to punish you. There's a discussion about, this wasn't raised at the trial court. There was, go back and look at the records, Your Honor. There were multiple oral arguments before this judge on these very issues, and it was lengthy, shall we say. Then they talk about the judge coming back and saying he made a mistake. Read the oral argument on the record, have one of your clerks, where he says, well, I made this decision that I was wrong because I was in the airport and saw a child. What? The jury didn't see that. He's supposed to look at what the evidence was, and what the judge did not say, the trial judge did not say when he went back and reviewed it is, you know what? There was significant evidence to support this, because simple fact, on the record, there is not.
Thank you, Counsel.
Thank you.
Counsel, I want to thank you both for your presentations and your briefs as well. We will take this matter under advisement and issue a written ruling in due course. We'll stand in recess while the courtroom is set up for our next argument. Thank you.
Thanks, you guys.